Can you continue the conversation on today's hearing about the Mar-a-Lago search warrant affidavit? We're joined by former U.S. Attorney for D.C. Joe DiGenova and former Chief Counsel for the Senate Intelligence Committee, Victoria Toensing. They are founding partners of the DiGenova and Toensing law firm. Joe, Victoria, welcome. I hope I said that correctly.
You're all set. Great job.
Good. Oh, good. Fantastic. All right, let's dive right in. Joe, we'll start with you. Your thoughts on this affidavit pending release?
Well, this judge knows he's under scrutiny. He's heard the complaints about him being a partisan and being an anti-Trumper. He knows that he recused himself from the Trump civil suit against Hillary Clinton in his courthouse, which he was in charge of. What he's doing is he's trying to make himself look good. So he's decided to release parts of the affidavit. Now, what they're going to release is going to be thin gruel. The stuff that matters, how the information was acquired, all that stuff is going to be redacted from the affidavit. I predict that we will learn very little from the affidavit, but I mean, at least it's something. But it's not going to satisfy people.
Yeah,
let me just clarify something.
Yeah.
And that is that the Trump people and the government cannot sit down and work it out, because right now the Trump lawyers don't know what's in the affidavit, and the government doesn't want them to know what's in the affidavit until they decide what they're going to redact. So you just couldn't go through that process.
Here's what I don't get, Joe, Victoria. I don't understand how a magistrate in a county in Florida is allowing a search raid on a former president of the United States. I mean, I can almost understand it if the attorney general is involved and says, we want you to do this, we're pushing for it. But how does a magistrate have that decision-making power?
Well, under our law, magistrates are allowed to sign search warrants and arrest warrants that are presented to them by the federal government, but usually the U.S. attorney for that district. Now, here's what a judge in a situation like this should do, however. He should carefully scrutinize the facts and the affidavit and ask a lot of questions before he authorizes a search of a former president's home. May I say that it is presumptively not going to happen. If you're a good judge, you sit there and you look at this and you say, just a minute. Now, let me see if I have this right. You want me to authorize a search warrant for the former president of the United States. Have you exhausted all other remedies? Is this absolutely necessary? Are you sure that everything you have in this affidavit is truthful? I know you all lied to the FISA court on many occasions. Am I being lied to in this affidavit?
But this magistrate did not do that. Now, I wonder why the government went to a magistrate as opposed to a real federal judge who has lifetime tenure. That's the usual process for such a serious case. And this judge, the magistrate, signed an unconstitutional search warrant. So he wasn't going to ask any of the questions that Joe's bringing up. He signed a search warrant that said that they could go in and seize any document created by the Trump presidency throughout his whole presidency for 4 years. That's a general warrant, and that is prohibited by the U.S. Constitution.
I'm at a loss to see how we authorize the search for all of those documents. That simply is not the type of particularity and specificity that is required in a case like this, in any case.
The statute, the main statute, 793, is an old wartime spy statute, and you have to have intent to harm the United States. Now, you tell me where you could get evidence that Donald Trump had intent to harm the United States.
Well, if it's not in the affidavit, I guess a lot of people are going to ask the very same question. So, Joe and Victoria, thank you so much.
Thank you.
Sure.